A lot of people think negotiation is going in there and pounding the table. It really is not. It really is not. It's about having a sensible discussion, knowing what you bring to the table, what they want, why they are trying to hire you, and then trying to find a nice balance in there that works for them and for you.
Welcome back to the Work It Podcast. My name is Nat, and today we are going to be talking about employment contracts. So joining me on the couch today is CNA Today journalist Loraine Lee, who spoke to recruiters and legal experts on what workers should watch out for.
Hi.
And Amarjit Kaur, head of employment at local law firm Withers KhattarWong, who will help us understand what all that legal fine print actually means in practice.
Hi, Nat. Hi, Loraine.
You've spoken to a few experts, you've done some interviews for an article you're working on specifically on this topic of employment clauses, right? So say you've got a new job offer, they want you to start before your notice period ends. Based on your conversation with all the experts, what route are you taking? What are you going to do next?
So there are some options. It's not the end all. You can talk to your future employer, perhaps ask them if they could buy over the time that you need to pay back to your existing employer.
Right.
You can also negotiate with HR. Just tell them, hey, this is a bit too long. I know I signed the contract, but is there any way we can relook and shorten this? Also, you could clear your leave. As in, I'm sure many of us would keep our ALs and clear it during this period of time. So it's not the end all.
Okay. And are these things that you knew before you got in conversation with these people? Like, would you have done this before?
No, I think I would be panicking. I would definitely freak out, and maybe I would be asking friends. But I do know a lot of my friends are not very certain. And also based on like some of my interviewees, a lot of them didn't know that notice periods can be negotiated. They thought that's it. They would have to either tell their future employer that they can't start ahead of time or simply let go of the opportunity.
Okay, because I can imagine the anxiety is that if you tell a potential employer, I can't join you for another 3 months because I have 3 months of notice, they're going to say, oops, we need someone right now, so good luck with finding a new job, and they go to someone else. So are there any legal workarounds?
Okay, so firstly, notice periods are enshrined in the contract in most cases, right? And therefore, they're contractually binding. If a contract is silent on notice period, the Employment Act actually has a statutory flaw. So that's the sort of minimum that needs to be offered.
Okay.
Now, are there workarounds? The Employment Act actually provides for the option of both parties to be able to buy out the notice period. And this is called paying salary in lieu of notice. In many cases, the prospective future employer says, look, I need you to start urgently, particularly if the employee is one that they're trying to headhunt or they really want on their team, then they would fund the payment of salary in lieu of notice.
Okay.
And that will allow them to buy it out. Now, what you can't do is just say, I'm only going to serve 2 months and then unilaterally make the decision and walk out, because that's not within your prerogative if the employer hasn't agreed to shorten.
Right. Let's say my current employer says that my notice period is 3 months, but my new company says they want me to join right now, and they are willing to break my contract. Is there a danger that my salary will be lowered because they've had to incur cost to recruit me, basically?
That's a very fair point. At a commercial level, that may be factored in, right? They may say, well, if we're going to pay for 3 months of salary, then we will take it back from him. You should, ideally, in an ideal world, get salary, get all terms agreed, and then discuss that, I am going to have to buy it out. If you want me to start earlier, we will need to do a buyout of my notice. And are you prepared to support me in that? Otherwise, maybe you can just hold on for the 3 months and I'll join as soon as I can after that.
Got it. The other thing is you were saying, contracts for notice periods can be broken if mutually agreed upon by both parties,
Yes.
the employer and the employee.
Yes.
If it is agreed upon in a meeting, maybe say my exit interview with my manager, and they say, you know what, actually you don't need to serve your notice, I'll be nice and let you go off. And then I turn around and sign with my new employer. Should I have gotten it in writing?
So the reality is a lot of these conversations take place orally, face to face, right? Most people don't have these discussions around, can we shorten notice in writing? But the conservative approach, the sound advice would be, After the meeting, when you come out, just drop a short email to say, as we discussed, we've agreed that I will only serve 2 months out of the 6. My last day of work is so and so. Thank you so much for your kind understanding. That's all you need to do to memorialize it in writing. Now, it's not just the fact of it being in writing that's sufficient, because there's a recent case of aerospace solution. The employee put in 5 pieces of evidence to say the notice period was shortened. Reference to 2 phone calls, WhatsApp exchanges, an email, and I think correspondence with a third party. Now, with all of that, the court was not satisfied that there was that the documents or the evidence actually evinced an intention on the part of the employer to waive or shorten, or to waive the fact that, salary in lieu of notice needs to be paid. So the contents of what is captured in writing is also critical. It's not just the fact of putting something in writing.
Right.
You have to make it unambiguous what the intention is.
It needs to be explicit.
It needs to be explicit. The wording needs to be clear. Otherwise, it's not going to be particularly helpful.
But is an email like enough? Like you mentioned WhatsApps, messages and all that.
Yeah.
Are all contracts, if say it's HR or someone of authority emailing explicitly, is that enough, or are some contracts you need a change of the contract?
Okay, that is a very, very good point. Always know what your contract says, because certain contracts will have formalities set out for amendment. So usually most contracts will say this contract can only be amended in writing by parties' mutual consent. Some will say you require signatures, etc. So make sure you're aware what the formalities are in your contract. If it just says in writing, an email will suffice. You don't need to do a letter or anything formal. WhatsApp is also considered technically in writing. But again, I would prefer email for formal communication, particularly if you intend to rely on it.
I'm going to have to check the fine print of my contract later. But I'm curious, Loraine, with the people that you spoke to for this article you're working on, have you sussed out what's kind of considered as a normal notice period for someone maybe in your position?
So most of the people I spoke to are, new to the working world, maybe a few years, under 5 years of working. So a lot of them said 1 to 2 months is pretty much reasonable. They say anything above 3, they feel like it's a bit too much. They say maybe that should be for their managers and bosses. And that's what I heard from HR experts as well. Like if you are a low-level executive, you shouldn't be seeing anything more than 2 months. But nonetheless, there are reasons for companies who want such long notice periods, even though we think it's unreasonable.
Right.
Like struggles to get new manpower, or perhaps your job, there's a project and you do need to hand over things, and that takes time. So it is possible. Certain careers require it.
Okay, but I wonder why employers would want someone who is likely mentally checked out to still be working for a salary for a
Right.
couple more months than they have to.
I do know somebody who had a 1 month notice, and that 1 month her boss did not trust her to do anything because he thought that she would be mentally checked out and wouldn't do a good job.
Wow.
So some employers don't trust their employees to do much during this notice period. But I do think that for people who you want to keep it professional, you want to keep a good relationship with your manager, with your employer. You never know when you might join them back, right? So during this notice period, you should still do your job, still be professional, get your work done, end it off on a good note, and then leave for perhaps greener pastures. Who
Right.
knows?
Especially if your industry is smaller, because then, word travels, people are going to know how professional you are.
Correct.
So definitely don't burn any bridges, basically. Right. So how often do recruiters see candidates lose opportunities, though, because of long notice periods?
If you're a low-level employee, most employers are not willing to wait half a year and perhaps a bit more if you want to take a break for you to start work. You're better off, you will need to risk your job security, quit the job ahead of time, and then start job hunting, sadly.
I think you alluded to this earlier, but there was a recent incident that involved a manager who served only 2 months of his 6-month notice period and was ordered to pay 36,000 Singapore dollars. So 6 months sounds pretty unreasonable to me. I know that Loraine talked about like 1 month, 2 months, 3 months, but 6 months.
Generally, the court views notice periods as contractual undertakings because they're usually enshrined in the contract,
I
right?
see.
And it's the period during which parties agree to unwind the relationship. You're in an unwinding phase, right? The courts don't normally assess the reasonableness of the notice period. because it is something that has been agreed, and there are ways out of it. So the legislation also provides for the ability to buy it out. So you're not, it's not as if you're bound without any way out. You can always pay salary in lieu of notice if you don't want to serve it. So the recent case of Aerospace Solutions actually touched upon this, and Justice Ng actually mentioned that because this is not any attempt to control someone's behavior, conduct, activities after they've left the job, it's while they're unwinding the relationship. And there is a way for them to reciprocally cut it short. The courts don't go into the reasonableness.
Okay, so even if it was 9 months notice, a year's notice, like the courts wouldn't step in and say this is kind of too much.
Okay, that hasn't gone to, as far as I'm aware, there hasn't been a 1 year notice that's been under review. But the general principle should still apply.
Okay.
Now, I know at a very human level, 6 months, as you say, half a year, grates a little because it's a long time. But the fact is that it's not uncommon actually to have C-suite level, senior executives, people who are in very niche industries or who do things that are very unique or very niche.
Right.
For business continuity purposes, companies do have good reason to keep them on, either for handover or to find a replacement.
Yeah, if at my level, if I have to sign a 6-month contract, I'll be very scared. I wouldn't know, what if I want to change companies? What if I'm not in a good relationship with my employer? I would think twice about signing the job contract. Yeah, I think a lot of younger people would think twice, honestly, because you don't have the time to also job hunt and wait for and hope that your future employer is willing to wait for you. You have to risk perhaps unemployment for a little bit and hope you can get a job shortly after the 6 months ends, or you might be living in limbo for a little bit.
Yeah.
And I also don't think we have the money to pay out a 6-month contract on our a 6-month notice period on our own, especially at lower levels, unless you have a very generous employer.
Amarjit, if someone is new to the workforce and maybe it's a tough job market, they're coming out of being retrenched, for whatever reason, they are desperate for a job.
Yeah.
And they see a job offer with a 6-month notice period, despite them being in a junior role, and they sign that offer. Can they later bring it to court and say that, they didn't have much bargaining power in the first place, so it's unfair of the company to expect them to sign this?
Okay, so you can definitely bring the employer to court. Whether you succeed or not is a whole other matter, right?
Okay.
Because the courts recognize that the power imbalance between an employer and employee is baked into the relationship. It's an inherent part of it where the employer definitely has the upper hand.
Right.
And essentially, if the employee was desperate at the point in time, and I understand, it is a tough job market. It is a situation where people are struggling. And they may be tempted to just accept all the terms, even though they realize that a 6-month notice period, to Lorraine's point, is going to make it very tough for them later on. But because they want the job, they sign it, right? My advice to them would be, don't wait until the point of unwinding, where you then have to think, do I even need to take the employer to court? Have the conversation early. Okay? They may say, I'm very junior, I have no bargaining power, why would they do this? But you don't know until you ask.
Right.
So if you don't ask, you don't get.
Okay.
Ask before you sign. Once you sign, you have given away all your power. You are now bound by the agreement.
So there's another thing that I want to ask about employment clauses, because there is notice period and then there's a non-compete clause. So what's the legal difference between these two? Are they both equally enforceable?
Notice periods are far more common. They exist in almost, most employment contracts. And if not, there is a statutory flaw, as I mentioned, in the Employment Act, which provides for minimum. Okay, so I think if you've worked for 5 years or more, it's 1 month's notice. Okay.
Right.
So notice periods, very common, largely enforceable. We talked about the case where the employee left without serving full notice. There was another case that just came out of the Employment Claims Tribunal where the employer terminated an employee who had reached retirement age without giving notice or paying salary in lieu of notice. And that was deemed to be a repudiation of the contract.
Okay.
So the employer then had to pay salary in lieu of notice. So
Right.
notice periods largely enforceable. Non-compete actually relates to not competing. In most cases, it's called a post-termination restraint after you've left the employer.
Right.
They are still common, not that they are uncommon, but they are more common for more senior employees, so mid to senior employees.
So it's more more for specialized roles, you would say?
Yeah, specialized roles, seniority, depending on the exposure to client information, sensitive
Right.
information, etc.
Okay. So for a non-compete clause, how do I know whether it could actually be enforced against me?
It's generally considered to be a two-part test. The first consideration is whether the employer is trying to protect a legitimate proprietary interest, whether they're trying to protect business interests. That can be things like trade secrets, confidential information, client connections, maintaining a stable workforce. Those are some of the considerations.
Right.
Second stage is if the answer to stage one is yes, is this reasonable in the interest of the public and also between the parties? Now, the courts normally look at three criteria. One, how long is the non-compete period? Is it reasonable? Two is the geographic location. So, if your job only entails working in Singapore, a worldwide restraint may be found to be too wide. And the third is activity scope. What is it preventing you from doing? And the courts look at what were you actually doing? What is your mandate? What is your scope? Generally speaking, the more narrowly drafted it is to suit your role, the more curated it is, the more likely it is to be upheld versus a very broad, very blatant,
Like an
all-encompassing
Right.
attempt to stop you from doing anything, which not only the company does, but they are all their group companies, etc., etc.
I had a friend who had a 6-month notice period, and then he had a 1-year non-compete clause. Now, how common are limitations like that?
Now, the one thing that everyone should check their contracts for is whether there's a clause that says that any period of notice or any period of time spent on garden leave will be offset from the non-compete period.
Right.
Because if it's not there, you can ask for it to be put in so that you're not stacking 6 months plus 1 year. You're doing 6 months and then your 1 year shortened by those 6 months. So you have 6 plus 6 months rather than 6 months plus 12. A lot of people think that non-competes are unenforceable in Singapore, full stop. That's not true. Okay.
Oh, okay.
So it's naive to assume that they would never be enforced.
Right.
They are enforced. There are cases where they have been enforced. But the practical reality is it's very expensive for companies to take these sorts of things to court to get injunctions. And it's not easy to get an injunction to stop somebody from joining a competitor or to stop the competitor from hiring your staff. So that's expensive. It's hard to get. But it doesn't mean that companies won't try. So there have been
Right.
cases where even if the non-compete clause is not great, they may still try to bring action just to maybe make an example of the employee. Or if it's they're anticipating that, the senior most leader at the apex of the organization's leaving and there'll be a massive attrition. They sometimes do that to send a message to everyone else, which is we will not take this lightly. So these things do happen. Uncommon, but there are attempts to enforce. Or they may just send a cease and desist letter. You may get some aggressive legal letters. So companies also do try to protect their rights.
Right.
Yeah.
But how often is it that, maybe they just have a vendetta against this person who's leaving and they want to enforce it by all means necessary? It doesn't matter how much it costs them.
Yeah, sometimes that does happen.
It does.
So sometimes
Okay.
it's personal, sometimes it's the role,
Right.
right? If you have the senior most guy leaving or a very senior person
The
leaving,
best in his field.
best in his field, that can be very disruptive to the organization.
That's true.
It can really affect the culture, particularly if this person is someone who's been driving culture, performance, financial
Right.
performance. So there are a whole bunch of reasons why you would want to stop somebody from competing with the organization. Sometimes it's personal, very often it's commercial, but they do take action for whatever they consider to be good reason.
Say your contract is very broad
Yes.
and you don't want to risk your company sending you a nice legal letter in the mail. What do you do? How do you deal with a broad contract when you can't identify what exactly your company considers a competition?
Lawyers will never say, I guarantee you this is unenforceable. And no lawyer worth their salt will say that, because in Singapore, you don't actually know until it gets to court what the court will deem reasonable in the circumstances, because again, very, very fact specific, right? If you think the chances of it being successfully enforced against you are very low, then, in that case, many people may start roles. They would, for example, not put it on LinkedIn, not do a rah-rah, right?
Right.
Yeah.
Avoid any press releases, any industry releases, announcing all of this, just lie low and keep their heads down. So I call this the catch me if you can approach. Also, people who are conservative will say, during my non-compete, I will do something else. Or I will, not take on the same role. I will go and use the time to upskill or do something else. So that's the ultra-conservative approach. It's a spectrum. It depends on people's appetite for risk.
I've also heard of companies just offering contracts to employees who they know are on non-compete clauses, but offering them job titles that do not infringe upon that clause, but their job responsibilities are mostly the same. So is that kosher, or what are we thinking?
Okay, so the thoughts on that are the courts will look at the substance of the arrangement, right?
Okay.
So if he's essentially doing the same thing he was doing in his previous role, but at a competitor, then that's likely to be, of course, depending on the clause itself, whether it's enforceable, that may be considered to be infringing. Yeah. As opposed to, just changing a title or plastering on a different title. That's more form rather than substance. So I think they will look beyond just the title to
Right.
what was actually being done, and is it an infringement of the activity scope.
Right. But the title is the flag because that's the one that's searchable on Google and all of that.
That's right. But I think companies are savvy enough to know that if it, looks like a duck, sounds like a duck, but
It's
it's called a chicken, I need to dig a bit deeper, right?
Right.
Yeah.
Okay. Now, apart from notice periods, non-competes, what other clauses would make you think twice before signing a contract with an employer?
If I have negotiated a deal and the commercial terms are agreed upon, for example, a starting bonus, right? And I see the contract says that this is discretionary and employer has absolute discretion to change it, reduce it, remove it. That is a red flag because this is something that we've agreed upon. It's a commitment. But then to frame it as a discretionary payment doesn't align with the substance of what we've already agreed to. So that to me would be something to consider. If you've already discussed terms, you have to make sure that the terms are accurately captured in the contract. Now, I wouldn't write things off because sometimes it could be an old template, it could be sloppy drafting.
They could be in a rush to get you on board.
Exactly right.
Yeah.
So I would identify what look like red flags to me and go back and discuss. I wouldn't just say, oh no, this employer is terrible. They're trying to take advantage of
Right.
me.
Negotiate.
Go back and have a discussion. If you have any concerns, identify and have a conversation in a non-accusatory manner.
Of course.
Because again, as I said, right, very often assume good intent
Mhm.
and then take it forward.
Okay.
It's
Yeah.
interesting you brought up old contracts and templates because I have experienced this where, I ask HR, I want to negotiate certain terms, and they said, this is the standard template. Every employee signs it. So if I want to negotiate these terms, what can I do if HR insists, this is the only contract we have?
So let's say they say we can't change the contract, but we agree to a side letter or side email which says we are varying. Of course, check that with a lawyer to make sure that it's properly incorporated
Right.
and it actually amends the terms, because I would consider it, a little bit strange if they're not prepared to amend the actual template. Now, why do HR not amend the template? At law, you can, right? It's whatever deal I strike with you as an individual employee, so I can amend it to take into account your concerns, right?
Yeah.
At a very practical level, some companies are very large. HR deal with a lot of contracts. And if everyone comes in and wants us to customize for them, you then end up running multiple different employment contracts, which is a nightmare for HR to manage. And if ever there's a sale or an M&A or some sort of agreement of that sort, the due diligence exercise of going through the various contracts can be very, very painful. So that's why it's very normal for HR to push back and say, no, we're not going to amend. Now, negotiation depends on understanding your leverage, right? So the main thing is to know if they really want me. And this is a term that's very important to me. Then use your leverage sensibly. Don't ask for everything to be changed. Focus on what it is you really want changed and say, look, for me to come on board, this is a deal breaker. I need you to amend this. Chances are, if you do it strategically, knowing your leverage, HR may agree to change. Yeah. So do it sensibly. Don't, I don't like the language here. Can we change it? This is not grammatically correct. So even as lawyers, when we review contracts, we are very judicious with the changes we propose.
Right.
To focus on the ones that are really important to the client. There are some that are, sort of outliers, doesn't quite matter to them. But the ones that are central, focus on those and know what you bring to the table. Because that allows you to have some say in the terms you agree to.
Okay. Loraine, I wonder if there is a type of employment clause, be it a long notice period, non-compete clauses, long probation even, that would make you pause before accepting a dream job offer?
Well, definitely salary, first things
Okay.
first. I mean, money always. I think discretionary bonuses would be something I would think twice of. If I go into a company thinking it would be amazing, the money would be good, and suddenly I realize, oh, but every term that I agreed on, this wouldn't be the case, I would think twice. And notice periods as well. I mean, as someone who is younger, I don't think I can deal with a 6-month notice period, admittedly. I do commitments, life, and all that. If I want to change companies, not having the flexibility of it would be a deal breaker for me, even if it's my dream job.
So actually, I think if Loraine were to see my employment contract, she would absolutely freak out, given what she's just shared. Because I do have I think, goodness, I haven't looked at it in a long time. I've been at the firm for 8 years. I have a 6-month notice period, and I think I may have a pretty long non-compete period as well. Which, I mean, looking at her expression, seems horrific to her. I don't know what
Yeah.
I was thinking.
I would think twice about signing that. Did you try to negotiate that?
No, professional services contracts are notoriously onerous on the employees when they leave.
To kind of wrap things up, if someone is listening to our conversation just thinking, wow, but this negotiation, this pushing back, this going back to the employer, asking my current employer and future employer, it seems like a lot of work. Plus, it feels like I'm going to push a lot. And does that jeopardize my offer?
I think a lot of people struggle with this because as Asians, we are not necessarily the best at asking for what we want. We don't practice it. I always say this is a skill. It's like building a muscle. You have to do it often. It's developing that thick hide to go and ask for what you want. But it's a very good question because it's an art to know when to stop. Firstly, getting started for us is hard. So please try, please ask. Because if you don't ask, you don't get. Have the conversations, but also be very alive to the responses you're getting back. What's the dynamic? Are they open to it? If they're open to it, by all means, go for it, right? Push the boundaries. And if they really want you, so know your leverage, know what you bring to the table, own what you bring to the table. Because they're trying to hire you too. We shouldn't just be so grateful to get a job that we don't think about, does this really suit our needs? So negotiate to some extent. But I always say don't push beyond the point of no return because employers form the impression of people who negotiate too hard, push too hard, that they are difficult, that they're going to be problematic. And that sets an impression from the outset, which sometimes you can't undo. So again, negotiate with skill. Do it skillfully. You don't have to negotiate aggressively. A lot of people think negotiation is going in there and pounding the table. It really is not. It really is not. It's about having a sensible discussion, knowing what you bring to the table, what they want, why they are trying to hire you, and then trying to find a nice balance in there that works for them and for you.
Right. I think one very important thing that you mentioned is that in an employment negotiation, you are not the only one benefiting by being employed. They are also benefiting by bringing you on board.
Yes.
So recognize your own worth.
Yes.
Bring that to the table when you're negotiating, and recognize when that can help you get more than what they're offering in the first place.
Absolutely. And they almost always have a buffer, which if you don't ask, you never tap into.
Right. Okay, that's good to know. Well, hopefully everyone can tap into that buffer. Amarjit and Loraine, thank you so much for helping unpack this conversation, help us understand exactly what we're all signing up for when we're getting into our jobs.
Thank you, Nat.
Thank you.
Thanks, Loraine.
Thanks.
For all of you at home listening or watching, if you want to read Loraine's article, it'll be out this weekend. Just head on over to channelnewsasia.com/today. But we want to hear from you as well. Would you accept a job offer if they gave you a 6-month notice period? Let us know in the comments wherever you are listening to us from, or you can write to us at cnapodcasts@mediacorp.com.sg. My name's Nat, and remember, you've got to know what you sign.